Welcome to this short 5 in 10 podcast, where we will look at light touch administrations. My name is Elaine Petterson, and I'm a partner within Brodie's restructuring and insolvency team, specialising in real estate insolvency. Joining me today is my fellow partner from our restructuring and insolvency team, Lucy McCann, who specialises in insolvency litigation. Light touch administrations have received a lot of press coverage recently and have been trailed as a new initiative in terms of protecting businesses during these extremely difficult times. The aim of this podcast is to help you to learn 5 key things about light touch administration in the 10 minutes that you have. Please don't worry, you definitely don't need to be an expert in this area to understand the issues which we will be discussing. We have plenty of those who can assist you if required. Instead, this podcast, and indeed the series of our 5 in 10 podcasts that we will be presenting over the coming weeks, are very much designed to give you a quick overview of the key insolvency issues being discussed and some market insight to take away with you. So let's start with the basics.
So, what does light touch administration refer to? It refers to the formal insolvency process of administration, which is regulated by Schedule B1 to the Insolvency Act, where an administrator is appointed and rescue a company where possible, but ultimately ingather the company's assets with a view to making a distribution to its creditors in accordance with the statutory order priority. The reason it's described as a light touch administration is that rather than the administrator carrying out the day-to-day management of the company, upon their appointment, they use the powers available, in particular under para 64 of Schedule B1 to the Insolvency Act, to delegate management powers for the day-to-day running of the company back to the directors and the management team. The key is that the company enters into administration and gets access to this powerful statutory moratorium which protects the company from its creditors and gives it breathing space. Having access to the moratorium in what is now being described as the mothball phase will be the key to a business's survival, as it will protect them from their creditors. Is light touch administration new? The power to allow an administrator to delegate management powers has always been available. We know anecdotally that light touch administration was used under the old administration regime by Ernst & Young, who were appointed as the administrators for Railtrack in the early noughties, prior to administration under Schedule B1 being implemented. So there is precedent for light touch administrations. In response to the economic impact of COVID-19, however, insolvency professionals have been thinking creatively about how they can rescue and help rescue as many businesses as possible through these very testing times. The recent proposal that's hit the headlines in relation to light touch administrations has been prepared by Mark Phillips QC, who's a preeminent insolvency barrister and who's garnered the support of fellow insolvency professionals, as well as the London Lawyers Association and also the City of London Law Society. The proposal, which has been circulated, allows administrators to use the powers available to them under para 64 of Schedule B1 to delegate the management powers for the day-to-day running of the company back to the company's management team. So far, it's been used in the administration of Debenhams, but it's anticipated that other administrations and other companies will seek to use light touch administration. What does it involve? The consent protocol, which has been prepared by Mark Phillips, is essentially designed to be a contract between the administrator and the management team, and it sets out very clearly what the roles and responsibilities of the management team will be. In particular, what management powers are being delegated and the extent to which those management powers can be exercised. For example, how much the directors can be authorised to spend in any one transaction, what contracts, if any, they're entitled to enter into. The consent protocol is not set in stone and is designed to be flexible and can be used and adapted to different types of businesses and different business models. What you will always expect to see, though, is a very clear limit and clear delineation set on any delegated authority given by the administrators. This is not simply the administrators being difficult, but really it's vitally important, and it's there to protect the administrators, because ultimately the responsibility for the day-to-day management, even though delegated, still remains with the administrators, and it will be the administrators that would ultimately be answerable to the court and creditors, and their use of this process will be scrutinised.
So why is it being used to respond to the economic impact of COVID-19? Well, the principal benefit of this light touch is that it will keep the costs of the administration to a minimum by allowing the administrator to fulfil essential functions only. The administrator will have a more supervisory or project manager role. However, as we mentioned, this approach is not, however, without risk, as where an administrator chooses to use this power, they will personally be liable for the actions of the directors and the company's management. Also, as this is still an administration process, there is no guarantee of the ultimate outcome, but ultimately this is a way to look to preserve the business whilst hopefully containing costs, which will be key for a number of companies dealing with the impact of COVID-19. So will light touch administrations apply to all companies? Well, the answer to that is no, and light touch administrations will not necessarily be suitable for all companies. Certain sectors or types of businesses might be more challenging than others to apply the model to. So, for example, those who are highly regulated, where it seems more unlikely that an administrator would be comfortable delegating powers back to the company's management. We've already mentioned that Debenhams have utilised a light touch administration, and retail is a sector where we might well expect to see more light touch administrations being adopted. COVID-19 has affected almost every aspect of the retail sector, albeit some specific areas such as grocery and online offerings are doing better. But by using a light touch administration, a retail business would still get that protection from enforcement from creditors, but the administrators will be able to delegate the operational and strategic control to the existing management team who know the retail and real estate sector best. Quite often there can be a stigma attached to retaining the involvement of existing management when a company enters an insolvency process, as there can be concerns surrounding how efficiently the business had been run. However, currently we're in a very unique situation where the shockwaves being felt as a result of COVID-19 are far-reaching, and it may be that light touch administration could be used in the retail sector as a way to allow the most appropriate team, the existing management team, to deliver the best outcome, whilst hopefully minimising costs, preserving jobs where possible, but avoiding the dilution of creditors' assets. Given that the detail on the government's insolvency-related measures intended to protect companies in the short-term period is currently still awaited, and although we have seen a number of tenants working with landlords to agree deferrals of rent as holidays, retailers are still incurring ongoing costs during this period, and as yet we don't have a clear picture on how and when we will transition out of lockdown. As such, we may see more retailers reaching for the light touch administration as a tool to make it through this time.
Given the exposure of personal liability and really their special status as officers of the court, administrators will have to think very carefully about whether it's appropriate to use light touch administration and to allow a company's management team to remain in charge of the reins. Scrutiny will come as to whether light touch administration has been used appropriately, and whether a company has been in financial distress prior to COVID-19. An insolvency practitioner would have to think very carefully about the use in those circumstances. Of paramount consideration will be the ability to demonstrate that a light touch approach will enable a company to survive and allow it to be rescued. The attitude of stakeholders such as lenders, landlords, employees will all likely to be highly relevant when considering whether to adopt a light touch approach. It's inevitable that some businesses will not be able to survive the effects of COVID-19. There are very few businesses who can sustain prolonged periods where they're not generating income. There's also a concern about what happens when the doors open again. Trading will not resume at the same levels that we know that they were pre-lockdown. The reasons for this is that social distancing restrictions will remain in place for some time, which will affect footfall and again businesses' ability to generate income. Demand might not be the same. We know that there are a vast number of people in our economy who've been furloughed, and there may be redundancies to come, which means that we will not have the same level of disposable income in our pockets. We know that businesses and boardrooms are adaptable and they will pivot and try and diversify, but the question really has to be, how far can they go? I read an interesting article recently about how crisis can spur invention, but it can rarely work miracles. It strikes me that this may apply to light touch administrations. We have insolvency professionals seeking to do what they can to try and take a flexible approach to the tools that are available to them to help rescue businesses. There's a clear desire there to help businesses and our economy, but the question is, how far can these measures really go? And it seems to us that for miracles to be achieved, that it's likely that further government intervention will be required. On behalf of Elaine and I, that just leaves us to thank you for listening. We hope that you've found this restructuring and insolvency 5 in 10 instructive, and we look forward to you joining us for our next 5 in 10s, which will be announced on our website. Thank you.